There are too many major threats. Let me name 5. Extreme poverty and pandemics plague our world, but instead of addressing these problems honestly and expeditiously, governments are engaged in needless wars fed by the military-industrial complex. Some countries spend 40% of their budgets in war and war-related activities. This is obscene. A second concern is the challenge to global governance posed by investors and transnational corporations whose only interest is short-term profit and not development or human rights. Current trade agreements do not ensure the primacy of human rights and actually stand in the way of their implementation. The so-called Investor-State Dispute Mechanism, ISDS, has led to egregious arbitral awards. Now, pursuant to Article 103 of the UN Charter, the Supremacy Clause, all treaties, including trade agreements, must conform to the United Nations Charter. If they don't, they are invalid. But this conclusion must be formulated not by me, a special rapporteur, but by the International Court of Justice. A third major concern is debt restructuring. The special rapporteurs Cefal Lumina and Juan Pablo Bohoslavsky have written excellent reports with pragmatic recommendations. But financial institutions and vulture funds are still causing huge damage to human rights in many countries, primarily developing economies in Latin America, Africa, and Asia. A fourth problem is the existence of tax havens. These must end, and international penal law must be used to prosecute corruption, money laundering, and tax evasion. A fifth concern is, of course, climate change, desertification, the rising oceans, etc. Commitments were made at COP21 in Paris, including concerning a reduction of carbon emissions and the imperative to shift to renewable energy sources, but these commitments are not likely to be observed unless there is an effective monitoring and enforcement mechanism. From the outset, these treaties lack democratic legitimacy. In their elaboration and negotiation, crucial stakeholders were excluded. The people were denied participation in decision-making that would significantly affect them. The agreements were kept secret and adopted through fast-track procedures. Fundamental flaws that require a complete revamping of the international investment regime. Future agreements should be negotiated publicly and ratified only after full parliamentary debate and public referenda. Bilateral investment treaties and free trade agreements with investor-state dispute settlement are incompatible with the human rights treaty regime and must be reformed accordingly. The United Nations Conference on Trade and Development should call a world conference to revise the international investment regime and ensure transparency and accountability. Provisions of these treaties that usurp the ontological functions of the state can and should be eliminated pursuant to the Vienna Convention of the Law of Treaties, in particular, Article 48 concerning error, Article 49 concerning fraud, Article 50 concerning corruption, Articles 51 and 52 concerning coercion, Article 53 concerning treaties that are against international public order, what is known as contra bonos mores agreements. And of course, Article 62 concerning fundamental change in circumstances, what is known as rebus sic stantibus. Bearing in mind the adverse human rights impacts of these treaties, The General Assembly should request an advisory opinion from the International Court of Justice declaring unconscionable provisions of these treaties null and void. The international law doctrine of severability allows for the elimination of ISDS without terminating the trade agreements in their totality. The same applies to the proposed investment court system, which would establish a one-way jurisdiction allowing investors to sue states, but not vice versa. The veto power is regularly abused in the Security Council to the point that some resolutions are not even tabled because a veto is certain. Unilateral sanctions imposed by one country or a series of countries have been repeatedly condemned by the General Assembly, by the Subcommission on Promotion and Protection of Human Rights, by the Commission on Human Rights, and by the Human Rights Council special procedures. And yet, they are not lifted. The U.S. embargo on Cuba, which violates numerous civil, political, economic, social, and cultural rights of a whole people, is a case in point. Multilateral sanctions are also a problem because they seldom achieve their goals but demonstratively cause enormous suffering to innocent populations. The UN sanctions regime against Iraq from 1991 to 2003 has been described by scholars and diplomats as a form of genocide. Two United Nations Assistant Secretary Generals, Dennis Halliday and Hans-Christoph von Sponeck, resigned their posts in Iraq in protest because, according to UNICEF, the sanctions had caused the deaths of over 500,000 children. Other estimates actually put the death toll above 1 million victims. The United Nations is and remains the world's principal international organization, and its charter, it's akin to a world constitution. Standard setting in all areas of human activity has been extraordinary. Monitoring and implementing mechanisms have been established. Enforcement, however, remains unsatisfactory, owing to the lack of political will of the participants and a tendency to apply international law arbitrarily or a la carte. More and more, world decisions are dictated by other institutions like the World Trade Organization, the World Bank, and the International Monetary Fund. All three should be made subordinate to the United Nations and incorporated into the system pursuant to Articles 57 and 63 of the Charter. Transnational corporations have also usurped functions that belong to the peoples of the world. Although TNCs exercise enormous power and impact the lives of billions of human beings, they are not subject to common transparency and accountability rules. This must end through the adoption of a treaty that imposes binding legal obligations on non-state actors, including investors, transnational corporations, private security companies, etc. Enforcement mechanisms must also be put in place. System reform is necessary, especially of the Security Council and its veto power. However, the veto is not always a bad thing. If exercised in a manner consistent with the purposes and principles of the United Nations, in particular to prevent war and illegal military adventures, it is legitimate. For instance, Security Council Resolution 1973, which led to the illegal use of force through an unacceptably expansive interpretation, should have been vetoed. This was the resolution on humanitarian assistance in Libya. One must always be aware that states do not always act in good faith, and the precautionary principle should teach us not to open doors to illegal interventions contrary to Articles 2, Paragraph 3, and to paragraph 4 of the UN Charter. The so-called responsibility to protect doctrine must be abandoned because it endangers the jus cogens prohibition of the use of force and invites geopolitically driven interventions. I propose instead the creation of a United Nations Parliamentary Assembly in order to give greater voice to civil society worldwide. This assembly could have an advisory function and act in tandem with the United Nations General Assembly. Moreover, the regional human rights court systems must be strengthened as envisaged in the San Francisco-based Unite for Rights movement. This is the global Bill of Rights that our organization has established. Whistleblowers are human rights defenders and as such deserve the protection of the United Nations and the solidarity of civil society. When governments fail to proactively inform the public about matters that eminently concern them, when governments fail to respect the people's right to know, when they commit major crimes, whistleblowers become necessary. Secrecy is indeed the great enemy of democracy and of the rule of law. I have personally visited Julian Assange at the Ecuadorian embassy in London, and I hail his personal courage and welcome many WikiLeaks revelations that have empowered civil society to demand accountability. The importance of Snowden's revelation on the illegal and unconstitutional breach of privacy conducted by the NSA cannot be overestimated. If we want to avoid the Orwellian dystopia, we must control the activities of governments gone amok. The principles of direct democracy, legislative initiative, referendum, recall, and impeachment must be used more frequently. Governments, parliaments, and courts have a responsibility to act, what I would like to call R2A, instead of the responsibility to protect that we already know. This is the responsibility to act proactively in the public interest. When they fail to do so, civil society must call them to account. Civil society also has a responsibility to act in solidarity with peoples and countries affected by extreme poverty, by pandemics, climate change, asymmetrical trade relations, debt crisis, etc. It is time to abandon exceptionalism and unilateralism and realize that planet Earth belongs to all human beings and to succeeding generations.